My intro's not there. Hello and welcome. We've got a bit to talk about today. There's a lot of documents that have come out, and I'm just trying to check to see this Katie Joy's statements. If you try to call me autistic, Sheila, or my I don't get. Hello, Sheila and Angel. You can. Well, so we have got to talk about 7M. So I woke up this morning and I'm still in my pajamas. I'm uncaffeinated. This is what I do for you guys. There has been a truckload of files that have appeared. So let's just have a look at this. So we have got all of these that have been filed. There's a notion of motion, memorandum, an affidavit of attorney, affidavit plaintiff, affidavit of plaintiff, affidavit of plaintiff, and a proposed order and document. We already know what the proposed order and document is. Now, this is all for the default hearing on the 21st of November. There's a motion hearing and a default hearing. The motion hearing, so if you remember that Katie Joy had her motion to deny. Okay. 7M had a motion to delay the discovery. They filed a motion. That's to be heard on the 21st of November. And then they've applied for default, which is also going to be heard on the 21st. Now, my whole point is that if you haven't filed a defense, then why does the other party need to hand over discovery? Because what is it that you purely need from them for your defense that you don't already? Because in your defense, you're either saying I deny everything or I admit to everything. There's no in between. And then after you've filed your defense and you're putting everything together, then, you just do discovery. But again, it's just bizarre. Anyway, Katie Joy posted on Twitter, and I thank you to all the people because I can't get onto her Twitter. She says, I see everyone is I see everyone is taking about my lawsuit with 7M. Should be talking. 7M has not complied with our discovery request. We've filed a motion to compel discovery. In an effort to get out of complying with our discovery demands, they're now trying to claim we missed deadlines when we did not. We haven't filed. I haven't seen a motion to compel filed. They missed the deadline and have been avoiding all attempts to send over legally required discovery to us. In an attempt to avoid discovery demands, they're now seeking a default judgment. We missed no deadlines, period. This is a desperate and amateur move in an attempt to not have to legally comply with discovery requests in the case. They have not been granted an extension for deadlines, an injunction, nor sent any discovery to us despite missing a deadline a month ago. They wrote to the court. The court admitted that they got the documentation and said they had to file a motion. They filed a motion that's to be heard on the 21st of November. Without discovery from my company, they know they cannot litigate this case. They have been trying every possible method not to comply with discovery demands. We requested they file a motion to dismiss due to their failure to comply. We have engaged with them the entire time. We requested they file a motion to dismiss. I don't think so. So that's what she says. So that's really interesting. I mean, that's the narrative she's pointing out. And I guess if the narrative can work, good luck to you. The whole fact of the matter is, what is true, she filed the 7M applied for their discovery to occur after the motion to dismiss was heard, because they said that if it was dismissed, then the discovery was not required because she would have to file a defence. If the motion to dismiss succeeded, they would comply with discovery requests. That's what happened there. That's what was said. We've gone through all those documents. So she hasn't filed a defence. She lost the motion to dismiss. Essentially, she hasn't defended herself, which is baffling. I find the whole thing baffling. I don't know why you wouldn't actually defend it. I know Uncivil Law covered it this morning, and I know that he's had a few interesting moments. So let's look at these documents. So this is the motive. So we've got the order. So this is the proposed order. So let's start off with the proposed order, what they would like from the court. Okay, now remember, this is to be heard on the 21st of November. So everything is written in past tense because, so this says it's proposed. So if the judge signs off on it, it will be in past tense. It'll be correct. All right. So this is the proposed order. Okay. Proposed order. The above entitled matter came before the undersigned Judge A. Michelle A. Davis on the 21st of November 2022 via Zoom. Amber J. Staggev appeared on behalf of the plaintiff. All other appearances were noted on the record based upon all of the files, arguments of counsel, and parties and proceedings herein. The court makes the following orders. Now remember that you write proposed orders just to save the court time, because that's easy just for the judge to add their signature to it. Now, the judge might decide that they'll grant some of the orders. They may not grant all of them. So anyway. So on the 4th of April, 2022, defendants were served with plaintiff's amended summons and complaint. On April 27, 2022, defendants filed and served a motion to dismiss. On August 24, 2022, the district court issued its orders denying its motions, defiance defendant's motion. This is where Katie Joy has come unstuck. Under the Minnesota Rules of Civil Procedure, defendants had 14 days after August 24 to serve an answer. Defendants failed to provide an answer within the time rules required by the rules. Plaintiff's motion for default judgment is hereby granted. She never filed a defense. And I had another quick look this morning. I cannot see a defense there. Judgment in favor of the plaintiffs against defendants Catherine Mansky Polson, aka Katie Joy, and Without a Crystal Ball LLC for the amount of $1 million is hereby ordered. It is ordered that defendants and all persons acting in concert or participation with them are permanently enjoined from publishing or republishing on the internet, websites, forums, blogs, social media platforms, and otherwise the following material regarding the plaintiffs. So if, for example, the judge grants this, she will not be able to say any of these things, that the plaintiffs associated with a cult, that they engaged in human trafficking, that they engaged in theft, that they engaged in sexual exploitation, they engaged in torture, statements that plaintiffs are engaged in kidnapping or holding people captive, statements relating to legal proceedings with the plaintiffs, statements regarding any relationship between plaintiffs and their business partners, employers, employees, and aka affidavits, statements regarding marriages to the plaintiffs, or other false and defamatory statements and described in the plaintiff's amended complaint. And remember, at this point in time, she's not denied any of them. So because there's been no defense filed, the court automatically accepts everything that 7M has said is to be true. So she won't be able to talk about any of it. It's further ordered that defendants shall remove, or to the extent not already removed, any videos, writings, or posts to contain any of the false defamatory statements aforementioned within paragraph 8 immediately. It is also ordered that defendants and all persons acting in concert or participation with them are permanently enjoined from continuing to interfere. Now, this word permanently enjoined, this That means that any one of her sources or anyone that she's working with on the documentary or all the people that she has behind the scenes are also going to be banned. You see, this has a bigger effect on her, let's just say, and most people admit that it is the C word, okay? It could be on the let's just say it is the C word. She's really just now made it bad for everybody. But anyway, so anybody in concert or participation with them, so anybody working with Katie Joy that has anything to do with 7M will be permanently banned from continuing to interfere with the plaintiff 7M's film's business relationships and contracts by sending or transmitting any emails, text, social media messages, letters, or other written correspondence with the aforementioned statements to current or prospective clients, businesses and partners, or its regulators of 7M Films. It's further ordered that this court shall retain jurisdiction of this matter for purpose of construction, modification, and enforcement of this permanent injunction. So this last paragraph is saying that they want the court to keep this file alive just in case she breaches it and they need to then do enforcement. Let the judgment be entered a court and then let that. Now, the judge might decide that $1 million is too much and they deserve less, and that's that they will amend it accordingly. But this is what they're asking for. This is the proposed orders. Okay. So then we go to, this is their notice of motion and default judgment. So now, so they've got the orders. This is their motion. So they're applying for default judgment. Take note, at a time and place to be determined by plaintiff 7M Films, Robert Shin, Miranda Derrick, James Derrick, will bring on the hearing before the Honourable Michelle Davis, Judge of District Court, its motion default judgment on November 21, 2022 at 1:30 p.m. via Zoom. Plaintiffs will and hereby do move the court at the above stated time and place for the following order for default judgment pursuant to Rules 1201.01 and 55.01 of the Minnesota Civil Rules of Procedure and other applicable law. The motion is brought pursuant to the Minnesota Rules of Civil Procedure and will be based on the files, records, and proceedings herein and the supporting memorandum and declarations submitted in accordance with the rules, together with such additional oral and documentary evidence as may be presented in connection with the hearing of this motion. So that's the motion that they're bringing. They want a default judgment, and they've written the orders. What do I think about her tweets? Well, I've said all along is that she can't talk about them not complying when she actually hasn't filed a defense. So there's an affidavit from Robert Shin, there's an affidavit of Miranda Derrick, there's an affidavit from James Derrick, and there's an affidavit from the lawyer. So I thought we might start with Robert Shin and see what he's got to say. So they're bringing the action. So now there's their affidavit, right? I'm going to make this as big as I can so we can follow along. So this is the affidavit of Robert Shin. This is 14 pages long. So it says the undersigned being first duly sworn deposes and states as follows. I submit this affidavit in support of the plaintiff's motion for default judgment. I am personally familiar with matters discussed in this affidavit. If called as a witness, I would competently testify about the matters discussed in this affidavit. In 2020, I started 7M Films as a talent management company to assist artists and content creators by handling the business side of their social media presence so they could focus on the creativity that has made them popular. I am the CEO and owner of 7M Films, Inc. The statements made by defendants as outlined in the complaint as they relate to myself and plaintiff 7M Films Incorporated are categorically false. Neither plaintiff 7M's Inc. nor myself are associated with a cult. The defendant's statements and social media posts have caused multiple dancers to leave plaintiff 7M's film. Defendant's statements and posts have damaged plaintiff 7M's film's business reputation in the industry as well as our public reputation. Defendants' false and defamatory statements have resulted in a decrease in new business opportunities for 7M Films. Defendants' statements and posts have caused plaintiff 7M Films to suffer pecuniary damages. Attached is Exhibit A, is a table of plaintiff 7M Inc.'s estimated pecuniary losses from the current date to the year 2042. These estimates were made comparing 7M Films Inc.'s sales income from the 4 months. Sales incomes from 4 months prior to when defendants began making their false statements to the sales income from the 4 months after. 7Ms have calculated that from the year 2022 to 2042, it will lose approximately $4.724 nearly $5 million from the dancers who have quit working from the company. Plaintiff 7M Films have calculated that from the year 2022 to 2042, it will lose approximately $3.9 million due to the diminished earning capacity for the dancers who have stayed with 7M. Plaintiff 7M Films has calculated that from 2022 to 2042, it will lose a total of $8.7 million as a result of the defendant's false and defamatory statements about myself, 7M Films, Miranda Derrick, James Derrick, and other dancers with our management company. That's a really good question, Vedandra. I don't know. I guess they're just trying to show that it's going to take them a long time to recover. Prior to defendants' false and defamatory statements, plaintiff 7M Films had numerous contracts with multiple organizations and their business was growing monthly. Plaintiff 7M's sales for 2021 exceeded $1 million. From February to December 2021, plaintiff Miranda Derrick brought over $150,000 in sales with 7M. From January to December 2021, James Derrick brought over $350,000. Defendants were aware of 7M's contracts with third parties and made several social media posts encouraging their followers to interfere with those contracts. That's referred to as tortious interference, by the way. Defendants' false and defamatory statements resulted in multiple organizations cancelling their contract with plaintiff 7M's Films. Attached as Exhibit B is a true and correct copy of email correspondence with two organizations which have cancelled their partnership with Miranda Derrick as a result of the defendants' false and defamatory statements. Defendants have solicited companies to remove their posts involving 7M Films Inc. and their dancers. Attached as Exhibit C are two posts made by defendants boasting about their interference with 7M Films. Defendants' false and defamatory statements have resulted in several organizations we have partnered with issuing statements that are in no way affiliated with our company or our dancers. Defendants' false and defamatory statements have resulted in lost expansion opportunities with multi-billion-dollar franchises. 7M Film estimates losses as the result of these lost expansions to be at least $10 million. Defendants' statements and posts have caused me to suffer pecuniary damages. I have never been charged for the crime of human trafficking. I've never been charged for the crime of kidnapping. I've never been charged with any crime involving sexual misconduct. The defendants' statements and social media posts have damaged my public reputation. The defendants' false and defamatory statements have caused me to suffer severe emotional distress. As a result of the defendants' false and defamatory statements, I felt personally under attack. As a result of the defendants' false and defamatory statements, I have been threatened and harassed by third parties. I declare under the penalty of perjury that everything I've stated in this document is true and correct. And signed by Robert Shin. Okay, so they've done 7M loss from dancers who quit. 7M's loss from retaining dancers. I mean, you could argue that it doesn't give you a proper, I'd like to see how they came to those figures, but hey, at the moment, she's not defended anything. So because she hasn't defended anything, hi, Miranda, thank you for the time you spent with us the last few weeks to potentially come on board as one of our influencers. After some further internal discussion within our team, we've decided that at present time, we're not going to have you come on board. We apologise for any inconvenience this might be causing you and hope to revisit a working relationship with you at a later date. All the best. Hi, Olivia. Thanks so much. Looking forward to the first content. Please provide next steps. Please see the fully cancelled agreements June 1, 2022. Welcome to your new point of contact, and they'll be guiding you through the steps. So essentially they'd signed on and then they said, no, we're not going to. For the same reason, we won't be able to run Miranda on our campaign. We will ensure that payment is taken care of for the work that has been done. But I wanted to let you know as soon as possible. I hope you can understand, and thank you again for your efforts getting the story set taken down. I hope you enjoy the rest of your week. Hope all is well. It's been brought to our attention that Miranda is involved in a bit of the scandal at the moment involving court accusations. While we wish this wasn't the case, Brand is asking that she remove the content posted for redacted as soon as possible. Do you think this could be taken care of? Yes, we can do that. So it's been brought to our attention. Coming back to discussion, we feel that there is some negative publicity going on in the media, so we'd like to not move forward with this collaboration. Lawsuits, promo ex Miranda. You mentioned redacted in your story. Hey Miranda, could you remove our story, please? We received a lot of criticism due to this collaboration. Thank you for your understanding. Hi there. Yes, I can do that now. Then it says, thank you. She says, thank you, Spanx. It says, do you support cults that control every single aspect of dog dancers' lives? Their pastor controls everything they do, their money. Every decision is controlled by the pastor and his team. They're told to submit and obey. The pastor allegedly takes away privileges when they don't obey, including jobs, friends, church, family, etc. That cool with you? Asking for a friend. Thank you so much for flagging this with us. We've removed the post to confirm it was not a collab of any sort, just a regram. We don't support 7M in any way and stand by supporting women. Thank you again for letting us know. Thank you so much, Spanx, for doing the right thing. So she's bragged about it and shown her private messenger. Why do they need to? Why? So she shared. Not only has she shared that. So she publicly shared that she contacted Spanx. She's publicly shown that what the allegation that they made is true. This is the Clippers. I have spoken to multiple talent agencies and managers along with the industry who have applied pressure to the Clippers management to cut ties to 7M. Again, she's bragging that she's, powerful and she's caused them to lose money. There you go. So, as I said, there's been no defense. All right, so this is Miranda's affidavit. So the plaintiff is one of the plaintiffs in the above mentioned matter, the affidavit for the purpose of seeking the default judgment. She's a professional dancer, model, choreographer, singer, and social media content creator. She's legally married to James Derrick, who is one of the plaintiffs. She's never lied about the existence of her marriage to plaintiff James Derrick. The statements made by defendants as outlined in the complaint as they relate to myself and my family are categorically false. She's never been kidnapped by 7M. She wasn't lured into the cult. She was not brainwashed by 7M's to think her family was abusive. She began her professional relationship with 7M's Films in February 2021, and 7M Films is still the talent management. When she began working with 7M, she had approximately 105,000 followers on Instagram and 680 on TikTok. From February 21 to July 2021, her Instagram followers increased to 153,000 and her TikTok followers to 104,400. By March of 2022, just before the defendants began posting about the plaintiffs in this case, my Instagram following had increased to 1.2 million and my TikTok followers increased to 721,000. Since March of 2022, following the statements made by the posts, my Instagram has remained roughly the same at 1.3 million, and my TikTok following has only increased to 952,400. So she's showing that she had this great big jump in followers, and now it's just a very small. In the 5-month period from November 2021 to March 2022, my gross income was $96,268. In the 5-month period from April 2022 to August 2022, my gross income was $90,069. Attached as Exhibit A is a table of my estimated pecuniary losses from the current date to the year 2042 as a result of the defendant's defamatory campaign against myself, my family, and my management company. I have estimated that from the year 2022 to 2042, I'll lose approximately $10 million as a result of the defendant's lies and defamatory statements. Defendant's false and defamatory statements have caused me to lose multiple contracts and long-term partnerships. Attached as Exhibit B is an example of a partnership which is cancelled due to the defendant's false and defamatory statements. Defendant's false and defamatory statements have caused organisations, including Bang, Chatbook, and Dough Fasting, to breach their agreements to work with me. Defendant's false and defamatory statements have caused companies to take down social media posts I was involved with and make public statements that are not affiliated with me or my management company. Defendant's false and defamatory statements have caused me to be harassed by media organisations and other individuals attempting to gain information about me and save me from a fictitious cult. The defendant's false and defamatory statements have caused me to suffer emotional distress. Defendant's false and defamatory statements have made me feel vilified in the public. Defendant's false and defamatory statements have made me feel personally under attack. Defendant's false and defamatory statements have caused myself and my family to have been threatened and harassed by third parties, and everything that she stated is true and correct. So let's have a look. So this is the income that she's saying that she's lost. Then we've got her agreement, termination. We are confirming termination of your 1st of June 2022 elite agreement. We wish to remind you, however, that you are legally bound to comply with the activity restrictions set forth in paragraph 10 for a period of 12 months following your termination, which shall come up on June 9th, 2023. In addition, you are required to comply with the terms set forth at paragraphs titled confidentiality, non-disparagement, and miscellaneous provisions. We thank you for having been an elite member and wish you all the best. All right, so that was that one. So they're showing all their evidence to show that she's actually been, that there have been a whole pile of stuff happen to them. So that was Miranda's one. We've got James now. Okay, so again, he says that he's one of the plaintiffs. It's in support of a default judgment. He's a professional dancer, model, choreographer, musical producer, and social media content creator. He's legally married to Miranda Derrick, one of the plaintiffs. The statements made by the defendants as outlined in the complaint as they relate to myself are false. I began a professional relationship with 7M Films in August 2020 when 7M Films first began operating as a talent management company, and 7M Films is still my talent management company. When I began working with 7M Films, I had approximately 465,000 followers on Instagram and 2.7 million followers on TikTok. From August 2020 to July 2021, my Instagram followers increased to 845,000 and my TikTok followers to 3.1 million. By March of 2022, just before the defendants began posting about plaintiffs in this case, my Instagram following had increased to 1.8 million and my TikTok followers to increase to 4.9. Since March of 2022, following the statements and posts made by the defendants, my Instagram following has decreased to 1.7 and my TikTok has remained at 4.9. He actually has shown a loss. So he's saying his total income between November 2021 and March 2022 was $214,000. In the 5-month period from April 2022 to August 2022, his income dropped to $81,854. Wow, that's a big jump. So he's got his estimated pecuniary losses. He estimates that he'll lose over $10 million. So again, the defendant's false and defamatory statements have caused me to lose several contracts, caused to suffer emotional distress, made him feel vilified in public, feel under personal attack, have caused myself and my family to have been threatened and harassed by third parties. All right. So again, his estimated losses. So I'm not quite sure how that all works out, but so that's the same document, I think. Yeah. All right. So that's that one. This is the mother of all. This is the mother of all. This is bringing receipts. So we've done that one. No, we haven't. This is This is the memorandum in support. So we've done the proposed order. We've done the motion. All right. So now we've got. Oops. So this now outlines the argument. Okay. Just having a quick look here. Another quick look here. Yeah. So is there? Yeah. So it's just that's the argument or the memorandum, and then we've got the affidavit by the lawyer. Okay. So let's have a look. So this is a memorandum of law. Plaintiffs have brought a complaint against the defendants for the following claims: defamation per se. I was hoping I better. Yeah, no, not a problem, Bo. I look, as I said, I'm not caffeinated. I got up. I'm still in my pajamas. Very professional I am. It's not even 9 a.m. and here I am delivering for you all. So, defamation per se, tortious interference of contract, commercial defamation, intentional infliction of emotional distress, negligence per se, deceptive trade practices, intentional interference with prospective advantage, and injunctive relief. Defendants have failed to timely serve an answer in this matter pursuant to Minnesota Rules of Civil Procedure, and therefore plaintiffs are entitled to default judgment. We know that. They haven't filed a defense. Some of these, if I reckon they would lose a couple of these, in my opinion, if Katie had actually defended it. But anyway. But because she hasn't defended it, they're likely that, yeah. Default judgment, it's 12 a.m. your time, says Miranda. Default judgment should be entered against defendants for failure to timely answer plaintiff's amended complaint. In general, the Minnesota Rules of Civil Procedure require that defendant shall serve an answer within 21 days after service of the summons upon the defendant. However, a service of motion alters this period of time. If a court denies a motion, the responsive pleading shall be served within 14 days after service of notice of the court's action. So remember, she filed her motion to dismiss, so she had 14 days from the motion of dismiss. Therefore, if a party serves a motion to dismiss, that motion will temporarily toll the time to respond to a complaint. However, if the motion to dismiss is denied, then the defendant has 14 days after they receive service of denial to serve an answer to the plaintiff. Such failure is grounds for default judgment. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend within the time allowed, or therefore, by these rules or by statute, that the fact is made to appear by affidavit that judgment default shall be entered. So essentially the law says that if they haven't filed a response, then they're legally entitled to default judgment. Judgment shall be entered in favour of plaintiffs against defendants, as defendants have failed to answer this lawsuit pursuant to Rules of Civil Procedure. Plaintiffs were served on April 4th, 2022. Defendants filed motion to dismiss on April 27, 2022. The court issued its order on defendants' motion to dismiss on August 24, 2022. The court issued its notice of filing of order and served the same on defendants on August 25, 2022. By operation of the Minnesota civil procedure, defendants' answer was due on September 8, 2022. The deadline for filing an answer is now passed. The defendant has failed to answer in this action. Defendant is therefore in default pursuant of Minnesota Civil Procedure 55.01b. Judgment should be entered against defendants as outlined below. Now, can you see anything in there about discovery, that discovery is essential to that? We might pull up the Minnesota Civil Procedures and have a look if we need to. So now they're reiterating their argument. The elements of common law defamation in Minnesota are that the defendants made a false statement to someone other than the plaintiff, that the statement tended to harm the plaintiff's reputation and lower the estimation in the community. And that's the case. All three prongs of common law defamation are present in this action. Defendants made numerous false statements. Some of the false statements are included in the amended complaint. Others have been made since the amended complaint was filed and served. So they're referring to the affidavits and where you can find them. These false statements were presented to third parties as defendants, published them through social media. The false statements not only tended to harm plaintiff's reputation, and lower them in the estimation of the community. But many of these statements are also made with the intent to harm the plaintiff's reputation, such as accusing the plaintiffs of being associated with the cult. Vedanta says, will she use the lawsuit against for her excuse? That can't be an excuse. That can't be an excuse. Just because you're being sued by defamation by another person, it isn't an excuse for not filing properly. I can't see how it could be, to be honest. So, anyway, the question of whether a statement's language reasonably conveys a defamatory matter is one for the law of the court to decide in Harmon versus Hahn and Foucault. In the court's August 25, 2022 order on defendants' motion to dismiss, the court found defendants conveyed a meaning which is reasonably defamatory when they accuse the plaintiffs of engaging in human trafficking. If you remember rightly, the judge did state that there were some defamatory statements made. In addition to human trafficking claims, defendants have claimed plaintiffs have committed other crimes of moral turpitude, including kidnapping, waterboarding, sexual assault, and the plaintiffs are a cult similar to the nature of Jim James cult. The defendants' statements that the plaintiffs are a Jim James cult, and we've got a footnote down here. Jim Jones was the leader of the People's Temple cult who initiated a mass murder-suicide at the Jonestown compound in Guyana, and then they've got their source there. And that they participated in crimes of kidnapping, waterboarding, and sexual assault amount to the same level of disparagement as the accusation of human trafficking. Given the egregious nature of the defendants' false statements against the plaintiffs, it is proper for the court to find them defamatory. As a result of the defendants' defamatory statements and continued character assassination against plaintiffs have suffered a devastating personal and financial losses. Plaintiffs have seen numerous business contracts cancelled as a direct result of the false statements made by the defendants in this matter. Plaintiffs have seen a significant decrease in new business since defendants began making false statements. So now they're saying, see the Shin affidavit, the Miranda Derrick affidavit. Several dancers have left 7M Films since defendants began making false affidavits, although exact damages and future losses as a result of the harm the defendants have caused are incalculable. Using the losses sustained in the 5 months since defendants started making false statements, they estimate their losses as follows. So their 2022 losses there and their future losses. Plaintiffs have also suffered loss expansion opportunities based on the cancellation of contracts with multi-billion-dollar franchises. Plaintiffs estimate their lost value of these opportunities to be at least $10 million. It's interesting how they've got these losses that they've got in millions and millions of dollars, and they're only asking for $1 million. As a result of the defendant's defamatory statements, plaintiffs calculate the damage for past and future losses as $39 million. In Minnesota, the recovery of attorney fees are allowable if authorized by contract or statute if the party has acted in bad faith. In the same vein, attorney fees are recoverable in conjunction with the defamation claims. So not only will she have the $1 million, she will have the attorney's fees as well. Plaintiffs have incurred thousands of dollars in legal costs in conjunction with this defamation claim and request the court award plaintiffs their actual attorney's fees in addition to the aforementioned damages. For the foregoing reason, defendants' false, malicious, and relentless attack on plaintiffs constitutes defamation under Minnesota law. As a result of defendants' defamatory statements, plaintiffs have suffered millions of dollars in money damages, as well as incalculable emotional and reputational damage, for which there is no adequate remedy at law to make plaintiffs whole. Where defamation affects a plaintiff in his business, trade, profession, office, or calling, it is defamation per se, and thus actionable without any proof of actual damages. Defamation per se are false accusations of committing a crime and false statements about a person's business, trade, or professional conduct. Defamation statements are defamation per se if they refer to improper or incompetent conduct involving a person's trade, business, or profession. Defendants in their false statements have alleged improper conduct involving plaintiff's business. Defendants have continually stated that 7M Films lies to their clients, exerts total control over the lives of their clients. Management has been grooming dancers for sexual exploitation, forces their clients' dancers to attend church, forces marriages between clients, dancers, steals money from clients' dancers, uses their business to engage in other criminal activities. Defendants have made false statements of fact, claiming plaintiffs have committed crimes and engaged in improper and incompetent conduct regarding their businesses. Defendants' conduct constitutes defamation per se, and the court should award the damages outlined in count 1 to the plaintiff. So, tortious interference. The elements of tortious interference with a contract include the existence of a contract, an alleged wrongdoer's knowledge of the contract, intentional procurement of the contract breached by the wrongdoer without justification that results in damage. Now, we've seen her bragging about doing this. Community Insurance Agency versus Kempler. All elements are satisfied in the present case. The plaintiffs include established content creators and growing management company that holds numerous contracts with various organizations. Defendants, by their own admission, have knowledge of these contracts. Defendants have procured breach of these contracts by using their social media influence and personal connections to convince parties who have signed a contract with plaintiffs to cancel them and cut ties with the plaintiffs. One such example is where the defendant boasted online about interfering with plaintiff 7M's contract with the LA Clippers and posted the evidence on Instagram. Other lost contracts include, but are not limited to, agreements with Bain, Chatbooks, and Dough Fasting. Defendants' procurement of these breaches is unjustified. Defendants had no interest in any contract involving plaintiffs. This interference has resulted in monetary and reputational damages. Plaintiffs' estimated pecuniary losses from the cancellation of these contracts is in the millions. Intentional infliction of emotional distress has 4 elements. Extreme and outrageous conduct is intentional or reckless that causes emotional distress and is severe. This is the one that I think, in my opinion, is the hardest one for them, would be their hardest one. But, she hasn't defended it. So, extreme and outrageous conduct is conduct that is so atrocious that it passes the boundaries of decency and is utterly intolerable to civilized community. Emotional distress is severe when no reasonable person could have expected to endure it. All of these elements are present in the current case. All right, so we're now going to see why they're saying. Defendants have created a social media campaign where they disparage plaintiffs and encourage defendants' followers to harass and threaten the plaintiffs. Defendants have posted personal and outrageous statements about the plaintiffs, including associations with human trafficking, questioning the validity of their marriages. The defendants' assault on the plaintiff's character have caused the plaintiffs to lose numerous business relationships. Furthermore, because of defendants' constant disparagement of plaintiffs, several affiliates of Plaintiff 7M Films have been harassed, threatened online. Defendants' social media disparagement has also caused irreparable damage to the plaintiffs' professional and personal reputations. Defendants' actions transcend all boundaries of decency and is utterly intolerable to the civilized community. Defendants have resulted in the plaintiffs suffering from harassment and threats. Further, the defendants have refused to cease and desist from these behaviours and have adamantly reiterated that they will not change their ways and will continue to post about the plaintiffs online despite the numerous requests to cease and desist. Defendants' disregard for safety of plaintiffs and refusal to discontinue posting false and defamatory statements about plaintiffs establishes reckless disregard for consequences of actions. The plaintiffs suffered severe emotional distress over the defendants' conduct. Overall, the plaintiffs have experienced severe mental anguish from lost business opportunities, personal threats, and public ridicule. No reasonable person should be expected to endure such continued and relentless trauma. Well, negligence per se. The elements of a cause of action for negligence are duty, breach of that duty, the breach of that duty be proximate cause of the plaintiff's injury and damages. Minneapolis Employees Retirement Fund versus Ellison Williams Co. Negligence per se is a form of ordinary negligence that results from statutory violations. A per se negligence rule substitutes a statutory standard of care for the ordinary prudent person standard of care, such as that a violation of a statute is conclusive evidence of duty and breach. All right, so a breach of statute gives rise to negligence per se if the person harmed by that violation are within the intended protection of the statute and harm suffered is the harm of legislation was intended to prevent. So now they've got here. So Minnesota statute defines criminal defamation as follows. Anything that exposes a person to group, class, association, hatred, contempt, ridicule, degradation, or disgrace in society, or injury to business or occupation. A subdivision 2 acts constituting whoever with knowledge of its false and defamatory character orally, in writing, or by other means communicates any false and defamatory matter to a third person without the consent of the person defamed is guilty of criminal defamation and may be sentenced to imprisonment for not more than 1 year or payment of a fine of not more than $3,000 or both. Oh, they've gone for criminal negligence, criminal defamation. Could she go? I don't know. Defendants have knowingly communicated false and defamatory material about plaintiffs to third parties without the consent of plaintiffs. These acts, as previously explained, have caused hatred, contempt, degradation, disgrace in society, and injury to business and occupation to plaintiffs. As such, defendants' conduct amounts to criminal defamation in violation of Minnesota statute. Therefore, the elements of duty and breach necessary for negligence per se have been met. Defendants are proximate cause of plaintiff's monetary and reputational damages. Interesting, it says that if she's found that there could be an imprisonment or a fine, could she be, interesting. That this criminal defamation aspect's going to be an interesting one. Defendants are proximate cause of plaintiff's monetary and reputational damages. Prior to defendants' first social media posting about the plaintiffs had a growing business and social media followings. Months after plaintiffs saw increases. I don't know, Vedandra, because we don't have criminal defamation in Australia. So does it mean she could go to jail? Could be interesting. Following defendants' defamatory social media campaign against the plaintiffs, they had their contracts cancelled, prospective clients dropped out of negotiations, and social media followers stagnated or decreased, and sales and income dropped significantly. Some of these contracts were cancelled as a result of the defendants' defamatory statements. But for the defamatory statements made by defendants and the dissemination of those statements to thousands of social media followers, plaintiffs would not have suffered the harm they had been suffering since March of 2022. Plaintiffs have suffered emotional, reputational, and monetary damage as described above. Interesting. Minnesota provides a cause of action for deceptive trade practices, including when, in the course of business, vocation, or occupation, one disparages the goods, services, or businesses. I'm going to be interesting to see whether the judge, as I said, there's been no defense, but I would have been interesting to see what they would have been able to get granted. So I'm very interested in the criminal defamation. I'm going to have to do some more research on that criminal defamation aspect, because that we don't have that one in Australia. But I'd be very, very interested to see, could she? Well, I mean, they'd probably just suspend her and give her it'd probably be suspended. But it depends on what the judge thinks, But as I said, she hasn't defended it. My whole point is she's not filed a defense. There's no leg to stand on. Right, so now let's get to deceptive trade practices. So Minnesota, she disparages the goods, services, or business of another by false or misleading representation of fact. The Court of Appeals of Minnesota has clarified that this tort is aimed at events that occur in the course of a business or trade. Overall, one can be liable for the tort of deceptive trade practices if A, the person acting in the course of their business or occupation renders a false or misleading representation of fact that relates to the plaintiff's business or trade, that calls plaintiff's trade or business, and all factors are present in the current case. Elements 2 to 4 of this claim have already been addressed in this memorandum. They'll focus on element 1 of this claim. Defendants engaged in this behaviour in the course of their business or occupation. Defendants monetize their social media presence by creating videos and internet postings through their various social media accounts, including Instagram, YouTube, Twitter, Facebook, and TikTok. All of defendants' statements were made on their main page, Without a Crystal Ball, which is the page for Without a Crystal Ball LLC. Therefore, the defendants' statements about the plaintiffs were made in the course of their business. Overall, the defendants' false and defamatory statements about plaintiffs constitute deceptive trade practices on the Minnesota statute 325D44, and plaintiffs are entitled to judgment accordingly. I mean, she could. I think she does. She might get a right of reply, but I mean, I don't know what. I mean, hello. But then she hasn't filed anything. So, but technically, I think you do generally get a right of. She will get a right of reply. She would have to prove that she's made no money. She would have to prove that she's made no money on any of those social media accounts. Intentional interference with prospective advantage. Minnesota recognizes an intentional interference with prospective advantage claim where, 1, the plaintiff has reasonable expectation of economic advantage. The defendant has knowledge that the expectation of economic advantage. The defendant intentionally interfered with the expectation of economic advantage, and intentional interference was independently tortious or criminal. That in the absence of the wrongful act of defendant, it is probable that the plaintiff would have obtained the expected advantage and that the plaintiff sustained damage. All of these are satisfied in this present case. Prior to defendant's social media attacks, plaintiffs had contracts and financial agreements with various entities. Plaintiff's 7M film sales for the year 2021, the first year they were in business, exceeded $1 million. From February to December 2021, plaintiff Miranda Derrick brought in over $150,000 in sales with 7M films. From January to December 2021, plaintiff James Derrick brought in over $350,000 in sales with 7M. Plaintiffs in this lawsuit had a reasonable expectation of economic advantage as they were making significant money through their business prior to defendants' statements. Defendants had knowledge of the plaintiffs' expectations as they promised to interfere with and directed their followers to interfere with the plaintiffs' economic opportunities until no one works with plaintiffs again. Defendants' interference was clearly intentional as they publicly boast about interfering with at least one economic opportunity with the LA Clippers. This interference was also independently tortious and defamatory as described above. In the absence of defendants' intentional interference, the plaintiffs likely would have obtained their expected economic advantages. Plaintiffs have suffered damages from the defendants' intentional interference since their calculated profits are in the millions of dollars. All of the factors for intentional interference with economic advantage are present, and the plaintiffs request that the court enter judgment accordingly. A party seeking permanent injunctive relief must demonstrate that there is a risk of irreparable harm for which no legal remedy is adequate, that the injunction is necessary to prevent great and irreparable injury. Irreparable harm can be actual or threatened. The party is seeking a permanent injunction must show that irreparable harm is likely, not just possible. In this case, in the absence of a permanent injunction, the plaintiffs will suffer irreparable harm for which there is no remedy at law if the defendants are allowed to continue their defamatory posting. The defendants' defamatory behaviour has caused the plaintiffs emotional and reputational damage for which there is no remedy at law. Plaintiffs' public images have been permanently sullied due to the malicious and defamatory attacks on them by defendants. Plaintiffs' business is centred around social media likes, follower accounts, and likability. Money is not a substitute for good reputation. No amount of money can compensate the plaintiffs for the public ridicule, shame, and damage to their reputation they've had to endure due to the defendant's conduct. If the defendant is allowed to continue, this damage will only intensify. Defendants will not willingly cease her defamatory campaign against the plaintiffs. Court action is clearly needed here to prevent harm to the plaintiffs, and the court is authorised to grant relief requested. So there's a case there. Affirming district court decision where plaintiffs have brought defamation action, seeking the order requiring defendant to remove statements and videos from the internet, ordering the removal of false harassing statements online. Given the ongoing harm by the defamatory posts' continued existence and defendants' failure to voluntarily address the issue, the requested injunctive relief in the amended complaint seeking a permanent injunction from further defamatory is appropriate. Plaintiffs set forth a valid legal complaint in this matter. Defendants have failed to timely serve an answer pursuant to the Minnesota Civil Rules of Procedure. Plaintiffs have properly set forth proof of damages in this matter, which supports the relief requested in the complaint. Therefore, judgment should be entered in favour of plaintiffs against defendant as outlined in the proposed order of the court. So we went through what the proposed order was, and they want no talking, that no one that she's associated with is allowed to talk about them. Removal of everything. So it's a big one. So this is the affidavit of the lawyer. So we've got, so Exhibit A is the summons and complaint. B is the process service affidavit. C is comments to a post. D is a social media posting. E is social media posting. F is Katie Joy's social media. So this is all their evidence that they're relying on. So we're up to PQ. Exhibit Q, social media posts. Let's go. Discovery is about to get real. And R is a of the case. So they've also attached copies of cases that they are relying on for their argument. I mean, I'm going to be very interested to see how she responds to this because, yeah. So this is the summons. Okay, this is the amended complaint. She holds herself out as an entertainment blogger. Wasn't it a journalist in Chrisley's case? Remember, now she's saying she filed an order to compel. I can't see that order filed. We can go back and have a look. So these are the statements, remember, if you remember, and they had all the links there, all the proof. The mere fact that in the judgment of the motion to dismiss that Her Honour said that there was some defamatory statements made really has got her backed in the corner. There's the Bentley comment, isn't it? WIACB is aware of where money came from, but we would like 7M to share where the money came from and which members' money was used to buy this Bentley. She has this thing about Bentleys, doesn't she? Anyway, so this is all set out for, as I said, the 21st of November. So again, this clip's been used a lot, where she boasted about getting that taken down. Yeah, to exceed $1 million, yeah. And they did want a jury trial, by the way. So that was the amended complaint, I think. This is the process server. Copy the process service. So now we've got 4 of the dancers that previously had. So this is data. What date was this from? They've just searched up. And she's got here 4 of the dancers that previously had their management have changed their bios to new managers and their that represent themselves. In the past few weeks, Aubrey, Carl, and Concrete, Gordon Watkins have removed 7M as their management company. All 4 were rep by the group. In a recent vlog from last week on Isaiah Shin's YouTube channel, the 7M group went to Universal Studios. The once huge crew is no longer. Something is going on. It appears a group of dancers are out. Kylie Douglas said on Instagram Live last night she's not part of 7M anymore. And then, of course, this is a completely false narrative. Okay, so this is my opinion. If you'd like to clear this up on all these, it's been cleared up. I just said it. Okay, but which part? Did I get it wrong that you left? The dance stuff is just my opinion based on what I see. Did you just unblock me? Yeah, just to say, don't start. That's not true on your page. So they've put that in there to show that the dancers are calling them out. Other accounts have enjoyed ridiculing, mocking, and bullying dancers in this story. I am not and will not be affiliated with any accounts claiming to be part of this story. That have done this. Too many of these pages have created unnecessarily drama. My team is behind the scenes. We care about this story. I'm on IG. I'm solo. Period. So this team will also be blocked from working on it. It says, I'm back to reporting on the 7M story and will continue. I have worked with the team since day one. I'll continue to share what I learned, but I won't be part of any pages. So there you go. And then this was an update, a judicial determination and lawsuit filed against them has not gone in their favour. According to a scheduling order filed in court on July 18, all discovery requests were due to be opposing by August 5. It's interesting that she never actually said that she lost her motion to dismiss either. So since April, plaintiffs have made no attempt for discovery. The judge is still on our motion to dismiss. Then it says, most interesting, many people have reached out to share that several of the dancers no longer have 7M listed. Could some of the dancers be leaving the group? Now, if you notice, it said it must be done via motion. So the court had said, we've got your letter, but you've got to follow motion. And then this is another one under new management. So she's posted again. An official statement. And of course, she shared it from Exposing 7M. And of course, she's talking that, there's no time or date shown. They've used Reddit. They've used Reddit. You spoke to Clippers, right? I did. Who did you talk to? The director of entertainment. The director's a friend of mine. I copied the VP to make sure it didn't get lost. And this is an email. And about contacting the court. So it says, we are requesting an amended scheduling order to be issued after Judge Michelle Davis has issued it on her order. So that was what they were wanting to do. They wanted the motion to dismiss ruled on first before they did it. So this is one of the cases that they're relying on, that they relied on. But yeah, as I said, that very interesting. So failures, yeah. So and I remember they used that one in their motion against the motion to dismiss. Look, if Katie Joy doesn't, she's got. I think she can. I mean, usually you do get a response for a motion, so she's got a chance to respond. But I don't know how you respond to that. The fact that they haven't filed a defense. How's she going to defend it? The only thing that can happen is settlement. And I don't think that it would be anything less than not talking about them ever again. And she won't want to do that. So she's got herself a little bit of a problem. Here's another one. Now, where this says positive, it's a case in the affirmative. So it's a positive. So it was one. And yeah. Okay, so this is on the day Homeland Security raided Josh Duggar. And then, so this is where they're saying, this is part of where they wanted parts of their concern is that she would broadcast a lot of the legal stuff. And so they put that in there. Okay. So they put that in there. That she's going to share court documents and, out of. And then this is the lawsuit, the Todd Chrisley one, where she's using that for her narrative. Again, how she's talking about lawsuits. Let's go, discovery about to get real. This is not filed in court. They've gone pocket service, which avoids the courts in Minnesota. Will be vigorously defending the claims. And we will countersuit against them for their pages smearing me. This will not stop my coverage of the situation. If you remember that. So, evidence with truth always wins. I'm sorry for the stress and expense of a lawsuit, but is it rude to say I'm looking forward to it? Gets popcorn. That's what somebody said. So again, this is cited cases. This opinion will be unpublished and may not be cited except as provided by Minnesota statutes. So as long as, so you can't technically cite it except for using Minnesota statutes. Okay. Yep. So anyway, that is all the documents that we've got. So there's a lot of them there. I've done that one. So they've gone out hard, and so she's, as I said, I think she's in my opinion, she's got a little bit. She's got a big uphill battle to get out of this one. I don't know what she's going to do. And the other thing is, Todd Chrisley says this as well. So Todd Chrisley's confirmed that there has been a settlement too. He says, I've been getting questions about my litigation with Katie Joy. All I'll say is that we've reached a settlement that I'm extremely happy with. As part of that, neither of us will be publicly discussing the other or the other's family going forward. Not at all. I'm glad to be able to put this out of my mind for good and won't be discussing the matter further. So she can't speak about any of the Chrisleys at all. So, you know, as I said, who's really had the win there? I'm interested. So, as I said, I'm just finding the whole thing. I don't know why she's focused on discovery when. How do you know what you need, what documents are needed if A, she hasn't defended herself and they haven't had a chance to respond to it. So I'm really not sure. She's also saying, she's going out hard here. This is interesting. This is just me. She said, we filed a letter and our answer to Robertson's attorney and the court today. The court never gave us a deadline to file. We have been in correspondence with Chin through his attorney since the beginning. We request they withdraw their motion or we will seek sanctions. And then it's got, please find, filed and served alongside the letter, a copy of the answer that we drafted. And this, I thought, had been sent last month. Given our typical manner of corresponding with you without delay, if you'd wanted an answer and had not received it, I would have thought it was. I thought we'd filed it, but we obviously hadn't. Please find filed it. Given so, in my opinion, they actually have to apply to the court for an extension of time to serve their out of time. I would have thought a simple email request would be, now I need to respond to the court to explain that your motion is moot or you can withdraw it. Whatever the case, you have your answer. You know my client's positions on the issues and default is not appropriate. Please advise whether we should spend our resources unnecessary in responding to a moot motion for which there has no basis in the first place. If you choose not to withdraw your motion, I will discuss with Ms. Possum whether she'd like to seek her costs or other appropriate sanctions for misuse of resources and abusive litigation process. Katie Joy, it was part of the civil procedures. I am certain that said that you had 14 days to file in the order. Let's go back and have a look. Oh, that's hilarious. How can it be mute if you haven't filed an answer? All right, let's have a look. That's hilarious. And Mr. Kraken needs to keep his girl off the internet, because guess what? All of this is going to be used as for the. I don't even live there, and even I know that would have been 14 or 21 days to respond. That's the usual time. Oopsies. Oh dear me. Someone's stuffed up big time. So let's look at motion. Let's have a look at this, because I'm interested in this and I want to see whether or not okay. Well, no. All right, I just want to see. So then I've got to do this one. Surely they would know what the procedure is. So surely they would know what the procedure was. Or don't they? Obviously they don't. So here we go. You see that on screen? All right. So here is the order. So the order attaches a memorandum incorporating made part of the order, and that was signed. So let's go to 8 pages. Yeah, that's right. So let's go to the order. Let's look at this further. I would have thought somebody would, like a lawyer, would know that you have. So this is the amended complaint. This is her decision. I just want to go back to so yeah, and motion to dismiss was denied. So Minnesota, just seeing what the civil procedure. Hang on, I need to just find. I mean, they put it out there though. What the here, Minnesota. How can they say it's a waste of court's time? Hang on, just got to change this. Here they've put it in this very paragraph right here. A default here's why. So Graham Cracker's saying they've got no default should be entered against defendants for failure to timely. In general, the Minnesota Rules of Civil Procedure require that defendant shall serve an answer within 21 days after a service of summons upon the defendant. However, a service of motion alters this period of time. If a court denies the motion, the responsive pleading shall be served within 14 days after service of notice of the court's action. Therefore, if a party serves a motion to dismiss, that motion will temporarily toll the time to respond to a complaint. However, if the motion of dismiss is denied, then the defendant has 14 days after they receive the service of denial to serve an answer to the plaintiff. Such failure is grounds for default judgment. So let's look at Minnesota civil procedure. Let's have a look. As I said, somebody's stuffed up here. I mean, Graham Cracker's gone and talked tough, but it's really interesting. He says, "Oh no, we thought we had it on our desk and we forgot to post it." That's the dog ate my homework. Here we go. Here's the civil procedures. All right, judgment. Where a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend within the time allowed, therefore, by these rules or by statute, and the fact is made to appear by affidavit, judgment by default shall be entered against the following parties as follows. That is what the court rules say. So the fact is they didn't file within time. They now have to file a motion asking for the court, or in Australia, you would actually have to file a motion asking for the court to accept your defence, your documentation, and you generally really have to have a very solid reason for missing the court deadline. To say that, I was in litigation with Todd Chrisley is not going to be suitable, or it was sitting on my desk and I thought I did it is not going to be a suitable answer. So, as I said, they're saying that it's frivolous, but I mean, I'm just finding the whole, everything that in that bit that she sent to the funny that she sent a confidential. She attached a bit of the letter that the lawyer sent. So yeah. But anyway, we'll wait. I guess we'll wait. Watch this space. We'll have her. We'll see what happens. Anyway, I'm going to love you all and leave you. I've got to get started with my day. I've got a full day ahead of me as well. And so watch this space. Thank you for joining me. Make sure you hit like and subscribe. Tell me what you think in the comments below. What do you make of all of this? But anyway, thank you very much. And I'll catch you again next time.